everyone, I'm Anshika. I hope you all are doing good. So, let's start today's topic, which is assault and battery. So, what is assault? An assault is one of the forms of trespass to person. It is an act which intentionally causes another person to apprehend the infliction of the immediate unlawful force on a person. It may be defined as the unlawful laying of hands on another or an attempt to do corporal hurt to another coupled with present ability and intention to do the act. The wrong of the assault is completed when the defendant develops the feeling in the mind of plaintiff that an act of violence is going to be committed. Winfield defines assault as assault is an act of the defendant which causes the plaintiff reasonable apprehension of the infliction of battery upon him by the defendant. Assault is also defined under section 351 of Indian Penal Code 1860 as follows: whoever makes any gesture or any preparation intending or knowing it to be likely that such gesture or preparation will cause any person present to apprehend that he who makes a gesture or preparation is about to use criminal force, that person is said to commit an assault. In further explanation of that, mere words do not amount to an assault, but the words which the person uses may give to his gestures or preparation such as meaning as may make those gestures or preparations amount to an assault. So what are the ingredients of assault? For the purpose of accomplishing the action of assault, the plaintiff has the burden to prove: number 1, that there was some expression or indication or preparation or gesture which created a threat or force, that the gesture or preparation or indication or even expression was reasonable such as to believe that the tortfeasor is about to harm him. Next is that there should be a prima facie ability to on defendant's part to convert the threat into execution immediately, that is the ability to the harm immediately. For instance, pointing a pitchfork, shaking one's fist in the face of another, pointing gun, whether loaded or unloaded, falls under the ambit of assault. Second, if fist or stick is shown from a distance where it is incapable of causing a harm, is not considered as an assault, as the harm should be immediate and cause reasonable apprehension in the mind of person. Mere verbal threat is also not an assault unless there is an immediate intention and ability to carry it out. So, here are the names of some judgments, landmark judgments relating to the wrong of assault. They are Tuberville versus Savage. Second, Stephens versus Mayers. Third, Birbal Khalifa versus Emperor. Fourth, Collins versus Willock. Fifth, R versus Ireland. Next, R versus St. George. Next, Embasco versus Logo Limited. And Thomas versus National Union of Mine Workers. So now let's come to battery. So what is battery? Battery is a direct and harmful contact with another person. It consists in touching another person against his will, however slightly. It is an intentional application of force against any other person without lawful justification in a rude, angry, insolent or revengeful manner. Just like assault, battery is also a form of trespass to person. It is one step next to that of assault, as it is the actual act of unwanted contact, and assault is a threat of unwanted contact. In battery, the amount or nature of force or contact does not matter. The least touching of a man in anger also constitutes a wrong of battery. For the purpose of battery, the required intention is to touch the other person unlawfully, and it is not necessary that there should be intention to cause any harm. The tort of battery is similar to the offence known as the use of criminal force under section 350 of the Indian Penal Code. Section 350 of IPC states states criminal force, that whoever intentionally uses force to any person without that person's consent in order to the committing of any offense, or intending by the use of such force to cause, or knowing it to be likely that by the use of such force he will cause injury, fear, or annoyance to the person to whom the force is used, is said to use criminal force to that other. Battery is the use of force against another person without any justification. The wrong is constituted no matter how small or trivial the force may be, and even no such harm is caused to the victim. Force doesn't always need to mean bodily harm. It can be caused through use of other things like a stick, heat, light, bullet, etc. It is without lawful justification. It is imperative that the use of force should be intentional and should not have any lawful justification. It is impossible for humans to survive without having physical contact with each other. Not every physical contact constitutes a battery. When the contact is aggressive and not required, it may become a battery. However, the use of force is justified when it comes to the saving of a person's life. In Lay vs. Gladstone, the force feeding of a hunger-striking prisoner to save his life was held as a valid defense for battery. Any injury that is caused unintentionally or by accident is also not considered as battery. In Stanley vs. Powell, the defendant was a part of a shooting party and he aimed to fire at a bird, but the pellet accidentally wounded the plaintiff, who was another member of this party. It was held that the defendant was not liable as the act was not willful. Use of force to oust a trespasser is also justified, but it should be reasonable. In Sharobi Grigoro vs. State of Bihar, it was held that fixing a live electric wire without due warning to keep trespassers away and causing the death of such trespasser was actionable. So here are the ingredients of battery. For accomplishing the action of battery, the plaintiff must have to prove first the use of force to him, either directly to his body or by bringing an object in contact with his body. Second, that use of force must be intentional and without any lawful justification. Third, the force must be exercised against the plaintiff without his consent. The consent should be express or implied. For instance, throwing the water to some other person is assault, and if the water falls on that person as intended constitutes a battery. Second, wiping a horse with another person is riding. Third, spitting on one's face. Fourth, causing another to be medically examined against his or her will. Next is carelessly firing a gun. So, here are some landmark judgments on the wrong of battery. First is Rixon vs. Star City Casino. Next, Scott vs. Stifford. Next, Letting vs. Copper. Next, Purcell vs. Hall. Next is Stanley vs. Powell. Next is Cole vs. Turner. And F vs. West Berkshire Health Authority. So here is the distinction between assault and battery. Assault and battery are the two terms that are more often exchangeable. They are two different legal terms. Battery includes assault. The main points of distinction are: actual contact is required to constitute a battery, while mere fear of physical violence is required to constitute assault. Sir Frederick Pollock said, "The application of unlawful force to another constitutes the wrong known as battery. An action which puts another in instant fear of unlawful force, though no force is actually applied, is a wrong of assault." Secondly, an assault is an attempt to battery or mere a threat to commit a battery. Sir Frederick Pollock says that battery includes assault in itself, where the wrongful act falls short of actual physical contact but creates an apprehension in the mind of another. The threat can immediately be converted into action. This is an assault. For instance, if a person runs while pointing fist towards another person with the intent of using force but falls short to a mere threat or fear, it will be an assault. But if he succeeded to come in actual contact of another person, then it would be a battery.